the big announcement from the U.S. Copyright Office about whether AI gets copyright comes out this week, and I see the name Jackson Pollock. Jackson Pollock is a painter from the 1950s. He's famous for splashing paint on a canvas and getting that known as art, even though some people question his randomness and his creativity, which is how someone tried to connect Pollock to AI, that if Pollock could get it from basically like prompts, he would throw paint, we throw prompts, out comes something that we didn't really see or visualize. It's from the act of creativity. Now, the U.S. Copyright Office did not see it that way, and they felt that, hey, there was a human holding a paintbrush, choosing color, choosing to throw it at that canvas, that there was a lot more involved. And maybe that's true, but the U.S. Copyright Office is sort of seeing AI like a digital roulette wheel. That's one of their own words. That they show randomly sort of choose out and puts together things, but it's not based on the expression that the person wanted to create. It's based on some random prompts and what comes out. So is that the way we're looking at AI? And will what has happened this week, and we'll go into it deeper in just a bit, will that really impact how we get creative with AI? Because right now, if it's just from AI, it's not going to get a copyright. Hey, I'm Declan Dunn, and this is the AI Optimist. We're talking about the fact that US copyright says AI can't author, but the New York Times case against ChatGPT may actually prove what they're saying is wrong, at least in my opinion. See, prompts get no respect from the Copyright Office, none at all. And I would actually equate this with the Chinese Copyright Office that we covered a few weeks ago on the podcast. They also looked at the early prompts as being good, but what are you doing next to show human creativity? If you're actually trying to create something just from prompts, the likelihood of you ever getting a copyright in the next 5-10 years is not high, at least in China or the US. Because both sort of look at prompt like spaghetti we're throwing up against the wall and seeing what sticks. And I'm seeing something a little different. I'm saying maybe AI is more human than we really think. Track with me here. Let's look closer what the New York Times did before we jump into the US AI copyright. The New York Times is suing ChatGPT, OpenAI, for taking their content, supposedly millions of pages. So they went through a very deliberate prompt process. And I was looking at the legal papers that are currently in there, because this case is a long way from being decided. But in there, OpenAI said they used tens of thousands of prompts, the New York Times. And that by doing that, not only did they violate the terms of service, but they did something that no one thought they could do. They got the content they expected out of ChatGPT, their own content that supposedly was taken. Now, this is a long way from being proven as facts, but this is what's alleged. So let's unpack this to say this is true. So if they took this out of ChatGPT, putting in tens of thousands of prompts, who cares, but a lot of work, months of work. And the expression, this is what's key, what comes out has to be connected to what goes in. That's why they're so stuck on human authorship. Because this we can predict, but if a machine puts it out through a probability, is that really creative? Is that new? And it goes into the public domain so we can all see it. That's part of what it's supposed to do. See, if the New York Times really got their content out, that actually is the first time we've connected the specific action to the specific prompt. So every prompt would shape an output just like every Pollock throw of paint created the canvas. The expression matching the intent, and we'll have to wait for the courts to decide this. It's all about the expression matching what goes in. If the prompt puts it in and something comes out, it's never exactly there. But the New York Times showed maybe it is. And I'm using them as an example to show that creativity is happening in prompts. And the same creative work that gets copyright protection, a Jackson Pollock painting, maybe is a little like AI. It is random. And that doesn't mean there is an intent. And that doesn't mean you can get something out. We'll have to see what happens. But let's unpack this and look at the new laws, the new rules. But the US Copyright Office, this is also number 2 of 3. The first one was on AI digital replicas and what you can do when using someone's image and using it in a replica and basically deepfakes. This next one that's up now was about AI copyright. Can we give copyright to things that come out of generative AI? And I'll share with you how they brought some actually really positive findings. But it's number 3 that's coming out probably about this time next year, if everything is right. That's really the key, because that's where they decide what does it mean when you put someone's content into ChatGPT. What licensing, what rules, what liability? Because you can't grant generative AI copyright if you find out later that you don't like the way the content was put together, like many creators say, you stole my content. So we really can't grant a copyright, but the most important thing that the US Copyright Office did was pretty much stay the same with all the decisions I've talked with you, mentioned a number of different cases, stayed the course. So let's unpack this and look at the new ways copyright is being looked at by the US copyright system and what it means to you as a creator. The strangest battle in AI, it's not about technology. It's about words written in 1787 in the US Constitution and 1965 when Abraham Kamenstein updated and shared AI-assisted versus machine. What's the difference? And just recently from the US Copyright Office. 4 guys in Philadelphia creating the Constitution never imagined ChatGPT. Abraham Kamenstein in 1965 talking about assisted versus machine-generated output could not even conceive of the skill set and people we are at now. But both of those rules are what's really guiding us as we figure out what to do with AI in the US for copyright. Because their words from way back now define our creative future. Here are the full list of conclusions and recommendations given by the US Copyright Office. The questions of copyright ability and AI can be resolved with existing law without the need for legislative change. So we're not going to have to change the Constitution. The use of AI tools to assist instead of stand in and create does not affect the availability of copyright protection for the output. So that means that you can use AI tools in your output as long as they're a tool and not the creator of the output. That's where the line comes in. Copyright protects the original expression in a work created by a human author, even if the work also includes AI-generated material. The example here is Zarya the Dawn. It was a comic book that was created with text and images. The graphic images, the characters came from Midjourney. The writing and the compilation of the book was from the author. So the author's whole book and those images within it can get copyrighted because it's part of something bigger. Though nitpicky, if they pulled the images out individually, they probably couldn't copyright the individual images. But as a whole, it can. So see, we can work AI assisted and include it in our work. They're really flexible with this. It's just when it gets to, if it's coming out of AI, that absolutely no copyright comes up. Again, always case by case basis. There's no absolutes here. Now, copyright does not extend to AI generated images purely from AI or material where there's insufficient human control over the expressive elements. Whether human contributions to AI generated work is enough, like Jason Allen's case, whether human effort contributed to an AI generated work is enough will be looked at on a case by case basis. And I'm hoping that's some hopeful news for Jason Allen with his many prompts and revising, who can clearly be seen as somebody who's left out of the copyright. But most of what this says could probably take a more favorable look at what he did because of the effort and his background and expertise, because it does matter. If you know what you're looking for, you can put it in. But if it's just me and I'm not an artist, I don't have much to stand on. Based on the current technology alone, prompts do not alone give copyright. Prompts are just too general and vague and roulette wheel for the US Copyright Office at this stage, the way they're looking at things. Human authors are entitled to copyright in AI generated work where their work is seen, the similarity, where you can notice that an absolutely copyrighted work was put in. An example from China is the Ultraman comic, which was revealed and showed that many of the characters that were used in the comic were coming out almost very comparable. It was really clear when you see them. And this is where at the end I'm going to come in because I don't agree with them, but I know it's early days. The case has not been made for additional copyright or sui generis protection for AI generated content, and I'm doing my best to pronounce that. That means a customized case for AI generated content, which I feel almost for sure will come up once they decide the third part in the US, how we can decide what copyright protections exist for people getting content put into the ChatGPTs of the world, liabilities, and compensation. See, until you do that, you cannot give any AI generated output a copyright even if you wanted to, because you don't know if there are other people involved. And those people are covered if their work shows up. So now we're going to talk about two cases that were used in the U.S. Copyright Office's notice that they put out and show a really interesting idea of what's authorship. Who is the creator? So the first one is the CCNV, that's the Community for Creative Nonviolence. There's a homeless advocacy group who commissioned a work artist James Reid created of people in front of a grate and looking over it, just like Jesus was left in the manger. These were homeless people this day over a grate being left out of their society. And so when it came to ownership, the CCNV said, wait, that's our sculpture, our copyright, because we said the ideas. Much like prompting. Can you connect where they're going here? We said the ideas. Then it just executed it like a machine. Now, the courts took a look back and forth on what went on, and it became obvious that James Reid did a lot more than just execute it as a sculptor. He had to draw a lot more into creating that. And so he showed that the expression came from him taking those directions and outputting it. In a way, we might call him what AI is. He got the prompts and he came out, and since he created it, there's the ownership. That's one of the really weird areas here. Is it the person requesting it, or is it the thing being created? And the weird thing with AI is we don't know where all that comes from, and it rarely repeats itself in a way that we can rely on in terms of imagery, words, content. So is it just a digital roulette wheel like they say? There is an element of truth there. The second case cited that I pulled out was the Andrian case from 1991, where the Southern Ocean County Chamber of Commerce had some maps drawn up. So when Louis Andrian asked a printer to rescale and print his collection of maps and specific instructions exactly what to do, he claimed authorship for the final work, giving the details. The Third Circuit Court had to determine if following detailed instructions qualifies as creative authorship. And the finding was, when simple transcription, quote unquote, creates the final form, original creator keeps the copyright. The Andrian case shows the difference between creative guidance and mechanical execution. And in this case, they were maps. So the intent wasn't just create a sculpture and then the artist takes it to another level, which in CCNV versus Reid gave Reid the copyright. In this case, there was so much intellect that it really was a case of the machine just outputting it. That's the argument, even from 1965, from Kamenstein, that said, if it's assisted, we can get a copyright, we're working with the machine, but if the machine creates it, there's no copyright. So the courts found in this case that the instructions were more important than what the machine was just doing what it was told. So this is where it defines between a tool and creative expression. Remember that New York Times? Because they're trying to actually get their own content. And if they did, snap, this is really an opening because of that creative prompting. So these two cases create a framework for evaluating AI authorship and were cited in the document because they really come to the key of the idea or the creation. And AI is a really gray area. We can say it is, we can say it isn't, but we really don't know what's coming out from the many engineers I talk with. And that's where it's not only weird, but it demands something new, doesn't it? Does the person directing the work, human or AI, add creative elements beyond the original concept? That's why in the map case, they lost because they really didn't add anything. Where in the artist case of Reid, they won because the artist added to the idea. See, it's all in that expression. That's where the real gold is. Are they making creative choices in execution or just following instructions? That's the argument against AI. It's just following instructions and doing math and coming up with something like a roulette wheel. The answers help determine who qualifies as an author under copyright law. So now, how do we apply it to the creators? What are you going to do with these findings? So I don't know where this will all come out, but that's what the AI copyright update in the US is all about. It shows us the gap between creativity and copyright. Your prompts might not be brilliant enough to recreate New York Times articles, but not creative enough for legal protection. That's our challenge, and that's the opportunity. We got to refine human authorship as the sole source, and that's going to take time. We need to know what's going in. Because at the end, if the Copyright Office compares AI to a roulette wheel, that's a real statement. And there is a lot of randomness and probability and an I don't know. But does that mean there's not creativity involved? I mean, if you don't prompt AI, does anything happen? Noise, right? Chaos. You just hit button, it doesn't even know what you're doing, it's just spinning the roulette wheel because you didn't give it direction. But with skilled prompting and parameter tweaking, you're not spinning a wheel. You're conducting a review of collected human knowledge. This is why I don't like the term artificial intelligence. I get it, obviously, right? But it's really the collective human intelligence, because without that data, none of this works. And without the code created by humans, none of this works. And without the person prompting or talking, because that's all it is a language communication with a database of incredible collective intelligence. And maybe our problem with respecting AI's copyright is respecting intelligence beyond just one human being an author. Maybe there's a collective element here, which is why I suggest a special customized view of the law is almost essential. Otherwise, you're reducing AI to what people in 1700s and 1965 said. And I get where that happens in law and it really helps us be a better society on one side. But this is way too new. And you don't even know what creativity looks like. And you're also getting in the way of people being creative with it because you're not protecting them. The New York Times are crafting precise prompts to get their content from ChatGPT, doing what most even AI engineers would say is pretty much impossible or extremely hard to replicate. If they create those prompts, doesn't that show that we can get something out of there? And that is the opportunity, the possibility that all of these copyright cases imply and why it matters so much. The Copyright Office got one thing really right. AI assisting human creativity, like Zari of the Dawn, the comic book, with images that weren't protected but the whole unit is, deserves protection. But they missed something bigger. AI isn't just a random number generator, it's collective human intelligence, seeing patterns we might miss, making connections we might never make because we can't access that much. Acting like it's a copy machine is such outdated thinking, isn't it? I remember talking about dated, the old movie Rain Man, where this autistic savant, played by Dustin Hoffman, was really, really brilliant at processing casino odds. Was his gift random, or was he seeing patterns in the chaos that others couldn't comprehend? We look at him differently in the movie, and it is a little dated, but it's more important that what he was doing is an example of a highly evolved intelligence we don't understand. And what we're doing is actually, I point the finger at us as humanity, looking at our own collective intelligence, every country, the biases. Wow, we think we're regulating single human authors? We're trying to say, how do we play in the world of copyright and collective intelligence of all of us, or at least those who create and put out? Hopefully with a little permission next time, folks. Next week, we're going to explore a new framework for protecting AI-assisted creativity, not forcing it into 1787 rules, not dismissing it as luck, but understanding it for what it really is: human intelligence evolved